Start. A finding of contributory negligence turns on a factual investigation whether the plaintiff contributed to his or her own loss by failing to take reasonable care of his or her person or property. Stop. What is reasonable care depends on the circumstances of the case. Stop. In many cases, it may be proper for a plaintiff to rely on the defendant to perform its duty. Stop. But there is no absolute rule. Stop. The duties and responsibilities of the defendant are a variable factor in determining whether contributory negligence exists and, if so, to what degree. Stop para. In some cases, the nature of the duty owed may exculpate the plaintiff from a claim of contributory negligence, in other cases, the nature of the duty may reduce the plaintiff's share of responsibility for the damage suffered, and in yet other cases, the nature of the duty may not prevent a finding that the plaintiff failed to take reasonable care for the safety of his or her person or property. Stop. Contributory negligence focuses on the conduct of the plaintiff. Stop. The duty owed by the defendant, although relevant, is one only of many factors that must be weighed in determining whether the plaintiff has so conducted itself that it failed to take reasonable care for the safety of its person or property. Stop. Para. Record reveals that driver of the tractor number UP 14A 1933 had maintained slow speed, prompting the claimant appellant number 1 to overtake, but, however, the driver of the another tractor bearing number UP 14B 9603 was rash and negligent in his act, inasmuch as, not only did he overspeed, but also came from the wrong side, resulting in the collision. Stop para. In the attending facts and circumstances, merely because a person was attempting to overtake a vehicle, cannot be said to be an act of rashness or negligence with nothing to the contrary suggested from the record. Stop. Further, it is the claimant appellant who lost a member of their family. Stop. Not only was the claimant appellant, Premlal Anand, doing an act which is an everyday occurrence on the road, that is overtaking a vehicle, but resultantly suffered extensive injuries himself. Stop para. That apart, it has also been proved that offending vehicle was driven rashly and negligently. Stop. These two factors taken together lead us to the conclusion that the finding of contributory negligence against the appellant number 1 was erroneous and unjustified. Stop. Consequently, compensation awarded on this count has to be revised. Stop.